Now back to the show. This is The Law Show on CL 650.
We can work it out. We can work it out. Life.
And welcome back to The Law Show on CL 650. Alyssa Lockhart is a partner at McQuarrieHunterLLP and Leah Donaldson, senior associate at McQuarrieHunterLLP. And we're talking about wills and estates, and that's the division you're in there at McQuarrieHunterLLP. So we touched on WESA, which is the new framework for your part of law that came in 2014. So, and I touched on this before. Will that mean that some wills are out of date, and how often should you update them?
Some, but certainly not all, and I would even say certainly not the majority. When I meet with clients on planning and I give them their brand new will, I always say to them, you should be reading this constantly. I would say if there's no reason to read it in the next 3 years, read it 3 years from now. But reasons to read it would be a change in your family status. So did I get married or divorced? Did I become widowed? And did one of my children pass away? Did one of my children have children? A change in your asset base. Did I sell my company? Did I acquire a company? Do I have assets that I can leave outside of my will through a beneficial designation that I didn't have before? What are my tax consequences on that? And should I be leaving certain assets in my will to my children and certain, for tax reasons, other assets that are, say, a RIF or RSP to my spouse from my second marriage? So there's those reasons. And then the third one is a change in your wishes. Mm-hmm. If I just decided not to include this person or this organization any longer, I should read my will and see how much I've left to them and how I go about changing that.
That's one of the things, maybe a misconception out there when this new legislation came in, that I thought as a layperson, WESA had sort of an umbrella that said you can't cut people out of a will. Mm-hmm. So you've got 3 kids and one you want to not give any money to. And I, as a layperson, I thought that WESA meant you can't do that anymore. Is that true?
No.
So the WESA combined several separate pieces of legislation. The legislation you're talking about is the Wills Variation Act, formerly. Mm-hmm. It was basically put into WESA under the WESA umbrella. So it's now part of the larger piece of legislation, but it remains in place.
So where has that misconception come that in British Columbia you can't leave people out? You're not allowed to do that. You can't uninherit somebody. Right. That's the way I heard it.
Yeah. So the Wills Variation Act, which we often hear, oh, it went away. Well, yes, it was repealed. It had to be repealed, which is erased, in order to be put into the new piece of legislation. So when people say that it's been repealed, absolutely not. It was repealed in order to be recreated lock, stock, and barrel in the new statute. It is broader than most other pieces of legislation in our country with respect to our moral obligation to those that are dependent upon us or were dependent upon us, our children and our spouses. So that broad moral obligation is a statement that we don't see in other statutes in other provinces. And that's where the concept comes from. When we look at that, though, what it says is fair, just, and adequate. Is it fair to leave my children each an equal third of my estate if one of them makes $500,000 a year and the other one makes $20,000 a year? Is it fair to leave them an equal share if one of them is disabled and physically cannot support themselves? Is it fair to leave them an equal share if one of them is actually just horrid?
Being a rotten kid.
Yeah. Just horrid, yes. So we have these falling outs. Sometimes we don't see our children for decades before our death. That person hasn't contributed to our well-being.
And what about the one child that is there and the other two, one's living in the States, one's living in Europe, but then you've got the oldest daughter that lives down the street and has been providing the care around the clock for the last 10 years. So does that person, did they get to say, well, I kind of do more out of this? Mm-hmm.
In a perfect world, I would like to see a completely independent parent entering their old age, coming to see me without, not at the behest of that oldest daughter. And I would like to see them setting up a personal care or a personal services agreement where it's very clearly set out what is being provided and what compensation will be earned, or whether whether it's gratuitous. If I bring somebody into my property, I want to know that I have a clear picture about what the rise in value of that property is. Is that my only reasonably large asset? And should I give it all to one child just because she was taking care of me for a year and a half while still able to go and live her own life and go to work and raise her own children? So we have to look at things in a broad scope, and we want to look at things with reasonableness in mind.
So is British Columbia the only jurisdiction in Canada that has this
No,
flavor
it's not the
to it?
only one, but many don't. So you might have relatives or people that have had experiences in other provinces, and the legislation is different there. So they might have, we call it dependence relief legislation, it's sometimes referred to as. They might have a form of it, but it's not exactly the same as ours.
Why is this? Because everybody is born and pays taxes and then dies, that this isn't a federal thing, that it's the same across the country. Why was this? Do you know why it was left to the provinces to come up with this? Because this affects everybody in the country equally.
Right.
You would think, right?
Absolutely. So it's a great question. The Constitution does provide for a division and a separation of powers. And so we have certain things where we're not so much a federalist state as other countries are. Our federal government is intended to involve itself in the broad spectrum, the umbrella issues, international affairs, defense spending, those sorts of things. When we look at the provinces in the Constitution, what their realm of authority is, it tends to be the day-to-day aspects of life, the things that affect all citizens on the ground from a personal level. And then when we look at the municipal authority that's granted under separate statutes, we see even a more direct impact on the day-to-day life,
They get to spend more of my money. That's for another show.
Yes, exactly.
Don't get me started on municipal.
Right.
But so it just seems to me that I understand the breakdown of powers, but somebody in Newfoundland has got a very different set of rules basically than we do here in BC.
Yes.
And is that a problem for some people? So you've got a brother or a cousin or somebody who lives in Ontario, and they think, well, my Uncle Joe just passed away in Ontario. It was very different.
We do see that, but there's also a set of laws that determine what legislation applies. And so basically you just need to get the lawyer in the right jurisdiction to give you the proper advice.
Now, can an executor be in another jurisdiction?
Yes. We are cautious always if an executor is outside of Canada. We talked in a previous show about what's the difference between an executor and a trustee. An estate is essentially always a trust. A trust is created when one person holds an asset, not as an owner, but for the benefit of another person. And with trust law, we're always concerned about a non-resident trustee because it makes the trust non-resident for tax purposes. So there's definitely a question.
So it actually moves it outside of the jurisdiction.
Well, it keeps it within the jurisdiction, but we certainly have within this jurisdiction rules under the Income Tax Act and other countries we have tax treaties with, and other countries have their own tax laws. They will be impacted by the fact that our trustee is non-resident. And so when we look at that, we sometimes say, well, we would rather have an executor who's present in Canada. I have executors that I work with in other provinces or even other countries that I never meet. The role is not necessarily one of being on the ground, although if you have a lot of personality, which is personal effects and articles, if you still have a home and a vehicle and all of your things are in your home, it's nice to have somebody who is capable of coming to the house, securing your assets, clearing out the assets, staging for sale, those sorts of things. But if you're elderly and you're living in a care facility, you've already downsized, you're predominantly liquid in your asset base, and your children live in Europe, that's not necessarily a bar to them doing a good job.
Now, I've heard stories of parents getting into joint ventures with property to try and skirt the tax man. And what I learned doing this show is that the probate that you pay, the tax you pay, is really quite small.
Yes.
And it's shocking to me. Everybody thinks there's this massive dark cloud, this death tax that comes in and wipes out all of your assets you saved your whole life for. But it's really not oppressive, is it?
No.
What is it?
Well, it's in British Columbia at the moment, and for as long as I can recall, it's been approximately 1.4% of the value of the assets that flow through probate.
So let's just say we'll pick $1 million, because a house can easily be $1 million in Vancouver.
$14,000.
And people are squirreling away, doing all kinds of crazy
they jump
things
through hoops
to try and save
There's a huge misconception, and I think what happens is, I'll craft powers of attorney for people, and they'll present them at the bank, for instance, or the credit union, and they'll say, I want to put this power of attorney on record so that my daughter can access my account. And they're told by someone who means very well, but doesn't understand that they're actually providing legal advice. They'll say, oh, sure, I'll put that on file, but it's easier if I just add their name to the account. Now, my daughter's the co-owner of my assets. If she has a divorce, or if CRA or somebody sues her and they have a garnishment order, does my account get accessed? And when I die, does she have to split the assets with her siblings? Or does she take it and say, well, I was the co-owner all along?
So with that $1 million and you pay the $14,000, all of that money is now free and clear to be dispersed and spent? You don't have to pay additional taxes?
No, and see, this is the thing. On property, so different from your bank accounts, but yours is a great example because people often think, I don't want to probate and cause a probate fee on my most valuable asset. My property is worth $1 million or $2 million, or if you're in Vancouver, I won't even go there, right? But what happens if my child doesn't live with me? What happens if my child lives in her own home in Abbotsford or Whistler or Europe? At that point, the rise in value of the property, the portion that she owns, she's not entitled to the capital gains exemption. So as I live in a property and it rises in value, I can get very happy about the level of equity that I'm amassing because I know that in Canada at this moment it's tax-free. So that, I look at that, say it's 23%, right? I mean, you're going to pay your marginal rate on 50% of the gain. So if we look at that and say, well, I'd rather pay 1.4% than 23%, that's pretty sensible, and I think most of my clients would agree. But we don't think about tax when we're simply going and asking someone to be transactional for us. So when clients come into lawyers, predominantly, we do not take instructions blindly. If someone comes in and says, I want to put my son Joe on my property as a co-owner, I'm going to ask a lot of questions. Have you considered the tax consequences? Does Joe live with you? Have you considered the consequences to your other children? Is it intended that Joe leave this as a gift or receive this as a gift after you die? Is it intended that Joe receive this as a gift right now? Will he be effectively a trustee right now until the moment of your death? Or will he be a joint owner, not only in name, but in beneficial interest? There's so many questions. So I think there we look at the difference between other practitioners and estate planning lawyers as not transactional.
Well, you went out with a flurry, I tell you. That was a great answer. Wow.
What can I say?
Thank you very much. That's the voice of Alyssa Lockhart, partner at Macquarie LLP. And Leah Donaldson is going to remain for the remainder of the show, senior associate at Macquarie LLP, to talk about the combination of wills and estates and the family law side and how it can get complicated. And Leah goes to court, so you've seen the worst. All right, we'll say thank you very much, and we'll continue the conversation next on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.